All right, let's jump right into this explainer. Today, we're looking at the jurisdiction of courts. We're going to break down exactly how this civil procedure system figures out which court has the absolute power to actually hear a case.
Now, before we get bogged down in all the dense rules, let's think about the real-world stakes for a second. Imagine a company based in Lahore completely wrongs you down in Karachi. Which court actually has the power to hear your case? I know it sounds like a totally simple logistical question, right? But honestly, knowing exactly where to file your lawsuit can literally be the difference between winning your case and having it immediately tossed out.
So, here's our roadmap for today's explainer. First, decoding jurisdiction. Then, limits on court power. Next, the 4 pillars. After that, where do you file? And finally, when jurisdiction goes wrong.
All right, part 1. Decoding the word jurisdiction. Black's Law Dictionary actually nails this. They define it as the authority, capacity, power, or right to act. You know, we so often picture a court as this massive physical building with a judge sitting up at some grand bench. But jurisdiction, it's simply a court's legal authority to administer justice. If they don't have jurisdiction, well, it doesn't matter how huge or impressive that building is, they have zero power to help you. So, looking at Section 9 of the Code, courts have jurisdiction to try all suits of a civil nature, unless their cognizance, which just means their right to hear the case, is expressly or impliedly barred. Basically, if an issue involves your personal or property rights, it's civil. And here's a really fascinating little detail. It's still considered a civil matter, even if those rights depend entirely on questions about religious rites or ceremonies. Moving on to Part 2, limits on court power.
Remember a second ago when Section 9 mentioned cases being expressly or impliedly barred? Okay, so expressly barred literally means a written law says, hey, civil courts cannot touch this, like specific acts for cooperative societies that have their own separate tribunals. Impliedly barred, on the other hand, deals with much broader concepts. A court just can't interfere with public policy or sovereign acts made during wartime. And listen, here's the absolute golden rule. Jurisdiction cannot be created by the consent of the parties. You and I can't just sign a contract to give some random court the power to handle our dispute. It just doesn't work that way.
Okay, Part 3, the 4 jurisdiction types. According to Section 15, you always got to start your lawsuit in the lowest grade court that's competent to try the suit. And to figure out if they're competent, you measure against 4 main pillars. First up is subject matter. Like a banking court handles banking, not trademark disputes. Makes sense, right? Second is territorial. A court's power is strictly limited to its geographic district. Third is pecuniary, which is just a fancy legal word for the amount of money involved. And fourth, personal. This is based on where the actual people involved reside or work. To give you an idea of how that pecuniary or money pillar works, let's look at Karachi. 15 million rupees. That is the magic number. If the value of your civil suit goes over that 15 million mark in Karachi, you don't start at the bottom. You skip the district judge entirely and head straight to the high court. The sheer monetary value literally dictates the exact door you have to walk through. Which brings us to Part 4. Where do you actually file? So for immovable property in Pakistan, we're talking real estate here, the general rule of thumb is to file where the property is physically sitting. That covers your standard recovery or partition cases. But take a look at this really interesting exception. A foreclosure, sale, or redemption suit that's tied to a mortgage, you can actually file that where the cause of action wholly or partly arose. So the law actually builds in some logical flexibility depending on the exact flavor of the dispute. But what if the dispute is just between people and not about land at all? Let's test this out with a personal wrong from Section 19. Let's say person A lives in Karachi, but beats up person B in Quetta. Where does B sue? I mean, if a wrong happens across city lines, who actually gets to pick the location of the trial? Well, the answer, and it's wonderfully laid out in the law, is that it's at the option of the plaintiff. In our scenario, person B is the plaintiff, the one who suffered the wrong. The law completely empowers B to choose. He can file in Quetta, since that's within the local limits where the wrong was actually committed. Or he can file down in Karachi, because that's where the defendant, person A, actually lives or works. It's totally by design to give the injured party a clear logistical advantage. Now, for your broader, everyday commercial disputes, Section 20 steps in and gives us 3 clear options. Step 1. You file where the defendant actually resides or carries on business. Step 2. What if you have multiple defendants scattered all over the country? Well, you can file where any one of those defendants resides, as long as the others acquiesce, meaning they agree to it, or if you get the court's permission. And Step 3, where the cause of action wholly or partly arises. And just a quick side note on corporations, they're legally deemed to carry on business at their principal office or to subordinate office if the incident actually happened there. Let's plug Section 20 into a real-world scenario so we can see it in action. A tradesman in Lahore sells some goods to a business in Karachi. The goods are dropped off at the airline in Lahore to get shipped. So where can the seller sue for unpaid goods? Well, following our rules, they can file in Lahore. Why? Because delivering the goods there means the cause of action partly arose in Lahore. Or they can file in Karachi, since that's where the defendant buyer operates. It creates a super predictable framework for everyday commerce.
And finally, Part 5, when jurisdiction goes wrong.
Filing in the wrong location is a huge deal. It immediately triggers the return of your plaint under the code. Basically, the court looks at it and says, yeah, we don't have the power to hear this. They hand all your paperwork right back and halt your entire legal process dead in its tracks. You have to start all over again. It is a massive, massive waste of time.
But guys, it gets so much worse. What if a court mistakenly hears a case they totally don't have jurisdiction over, and they actually issue an order? That order is considered a nullity in the eye of the law. It is completely void. Think about that for a second. You could spend 10 years passionately fighting a case, spend an absolute fortune on lawyer fees, and actually secure a winning judgment, only to have the whole thing completely erased because the court lacked the fundamental power to grant it in the first place. No limitation runs against a void order.
Which leaves us with a critical final thought to wrap up this explainer. If a court's ruling can become a complete nullity, are you truly certain your case is in the right hands? Before you start gathering your witnesses or passionately arguing the facts of your dispute, you absolutely have to master the power of the forum. Because at the end of the day, the greatest legal argument in the world means absolutely nothing if you're making it to a court that has no power to listen.